Number 42, People versus Caban.
Ready for court, please?
Counsel, do you want any rebuttal time?
3 minutes, please, Your Honor.
3 minutes. Go ahead.
Good afternoon, Your Honors. I'm Mark Krupnick on behalf of the people. To begin, the fact that the defendant's license was suspended critically at the time that the defendant struck and killed the victim in this case, it was relevant to the jury's criminal negligence determination at the trial in the proceedings below in particular.
Now, going back to the Molyneux application that you made to the court, there was no indication on the motion papers that the license was suspended at that time, nor in the responsive papers by the defense. Was it suspended at that time?
I'm sorry. You'll find that in the colloquy on pages 22 to 40 on March 29th, there's a further discussion regarding the nature of the suspension. The defendant had pled guilty to that actual offense.
The day after the accident.
Because it is reason to know your license is suspended as much as it is actual knowledge. So, and she pled guilty to it, even though the the paperwork dated January 9th after the accident came afterwards. But for the sufficiency of the notice, I don't think is really in dispute as much as the relevance of the actual proof itself.
You wanted to put in the whole thing. You wanted to, for purposes of negating mistake or
state of mind.
Yes, state of mind.
What's the state of mind that you're interested in?
As defined by this Court in People v. Haney, the forerunner to Cabrera, the state of mind is the failure to perceive a substantial unjustifiable risk of harm and a gross deviation of the standard of care.
But what's suspension got to do with that?
In two respects, and we're talking, if I may, just to really frame the issue, it's one, not of legal sufficiency, but of the lower threshold of relevance. And it is relevant, it has a tendency and reason to demonstrate, first, the defendant's state of mind, in that the State of New York didn't just put up a warning, it put up a big red stop sign that says, do not drive. She did it anyway. And it is serious blameworthy conduct itself, in that it violates a criminal statute, in effect a stick, more so than a carrot. But beyond that, it goes right toward what this Court said criminal negligence is in its essence, and that is it's obviously socially undesirable, which is aggravated unlicensed operation. It's designed to stimulate people's awareness of the risks of their conduct. And here the defendant's operating a heavy piece of machinery in an urban area. And it goes on and on.
But if it's suspended because you don't pay parking tickets or something like that, to me, I think you would agree that's an oversight that does not relate to someone's ability to drive or to observe or whatever, and the relevance would be less than if it got suspended because you have a tendency to run down pedestrians.
I would say, and assume we're not talking about scofflaws, like the worst of the worst in parking tickets, but I believe because Molyneux is a discrete two-step inquiry, that question is better left to the exercise of discretion in balancing probative versus prejudicial effect, and it would be harder for that to survive. But in terms of pure relevance,
didn't we say in Cabrera
that
that the issue is whether, or didn't we imply that the issue is whether it had attended, whether the license violation contributed as a causal matter to the accident?
I believe the exact word is criminal culpable risk creation, and I believe that the palpable tragic reality of this criminal case is that but for the fact that the defendant, had she not gotten behind the wheel of the Jeep, as the State of New York told her to, there would not be a dead 81-year-old grandmother.
Is there a difference, counsel, between a junior license and Cabrera, and the restrictions on it, et cetera, than this situation? How do you size up the two situations?
Well, junior driver's license violations.
And there it was relevant, right?
There it was, and a fortiori here, because junior I'm sorry.
Go ahead.
Junior driver's licenses are administrative violations. This is a crime, and it's the license suspension is tied in concurrently with the operation of the Jeep at the moment of the crime.
Would you then say
if that's the case, then why wasn't the underlying facts that she had previously backed up this Jeep and trying to abscond from police, why wasn't that more relevant to her state of mind? She obviously knew she wasn't supposed to operate a car that way.
And I think that's part of the irony of this appeal, is that the defendant is the beneficiary of a very generous in limine ruling that in the balancing in the second stage, the judge kept out that additional relevant proof and let in the license suspension. And now, in effect, if she gets to maintain this reversal, it's a huge windfall for her because both pieces of evidence are relevant as they go toward what this Court said.
Suppose we were to decide that the judge was wrong twice, that what he let in was irrelevant and what he kept out was relevant. How does the case come out?
Well, if there was some error, if you feel that there's error, then we would have to go to harmless error.
Well, and I guess what I'm saying is, suppose you're right that the underlying conduct is indeed highly relevant, but that it might still be an error to let in the license suspension without the reason for it.
You would have to squarely address the language in People v. Haney that sets the standard and determines what is relevant to criminal negligence, and that the jury, as directed, is the finder of fact to consider, quote, all of the circumstances surrounding the defendant's conduct. And here, the defendant, in effect, she was given a warning not to drive. It is blameworthy in that regard, and this is the kind of thing that Molyneux should not be kept, that the jury should not it shouldn't be concealed from the jury when they're trying to assess the contested state of mind of the defendant driver.
Well, that gets back to my original. Let's assume for a minute that someone's driving at night and they get stopped by the police and told your headlights are not working, so you shouldn't be driving this car. And they say, thank you, I'll get it fixed. The cop leaves and they just drive with no headlights and end up hitting someone. It would seem to me that's relevant that they were warned by the police.
Because of the standard of care in the statute.
That would be, but if they never knew, and they said, I never knew that my headlights were not on, then that's a different story. The same thing seems to me to be here. If the reason your license is suspended is for something innocuous that does not go to your ability to drive, to see what's there to be seen, et cetera, it's irrelevant to this case. On the other hand, if you're suspended for the very conduct that you are now being charged with, it may be very relevant.
The underlying conduct and the fact of the license suspension, I submit, were all relevant. The defense is relying on what you're referring to, which is a line of civil cases with which a lesser standard of care of just ordinary non-perception of risk.
But you then run into Sandoval. I mean, the idea that you could put in something that says she has a tendency to drive, to run over pedestrians, and we'd like to put in this suspension because that's what this suspension is based on, is not going to be admitted because it tends to prove the case without going to the facts of the case.
There is a probative non-propensity purpose that allows for its admissibility in terms of pure relevance in the first stage of
And that's that she
Molyneux.
never should have gotten in the car in the first place.
That, and it also speaks as to her other wrongful acts. The fact that her license was suspended, and I'm talking only in the criminal negligence context, not civil, but there's a higher standard for serious blameworthiness. And here, as she's backing up through a red light, as she has a man-made defect blocking her view of the ultimate victim in this case, that license suspension, the jury would be able to consider as it should have stimulated her awareness about all her other risky conduct in the same case.
I'll leave you alone after. Let's assume that everything she did was generally safe. There wasn't the plastic in the window that she was backing up. And now, would a jury be right in convicting her, saying, well, she seemed to be doing it safely, everything seemed to be all right, but don't forget, she had her license suspended. She should not have been on the road at all. So regardless of how safe she was, because she should not have been on the road and she hit the grandmother, she's guilty.
I believe that feeds into footnote 2 of the dissent in Cabrera, where the comment was made. It's a difference between legal sufficiency, that standing alone, a license suspension, does not rise to the level of legal sufficient proof to support a conviction.
I'm saying it should be admitted at all.
Yes, because it does go to her state of mind that she's contesting. In the language of Alvino, the defendant proffered a defense. This is a hotly contested issue, her state of mind, and the defendant proffered a defense in the nature of confession and avoidance. She said essentially, well, to the jury, well, perhaps at worst I might have been just civilly negligent. Blameworthy maybe, but not to the level of criminal, serious blameworthiness in the criminal negligence context. And so the people were at least entitled to refute that defense and also prove that element of the crime, which is a non-intentional mens rea element. It's exactly what Alvino talks about in that we're not bound to stop at the minimum, but we're entitled to present all relevant evidence, relevant in the sense that it goes to, it bears upon the issue of the defendant's state of mind, the operation of her mind.
Can I just ask, other than the response to your motion, did the defense object on the record?
You're leading to the preservation question?
Regarding to the suspension and the admissibility of that evidence?
I'd like to, in very quick bullet point-like fashion, show where it's preservation is
Where is it
demonstrated.
preserved? Because otherwise we can't reach it. We'd have to dismiss your appeal.
Of course. And if you allow me just to start with a very eloquent way of stating it, on page 66 of our appendix, the introduction of the suspended license was fully and timely preserved. Defense counsel had always...
You both switched sides. I mean,
Yeah.
of course, you're reading from you. She'll read from you when she stands up. But what about the merits?
But it also cites the March 29th proceedings, where the defense attorney says it's been our contention from the beginning of this case that the license suspension was a collateral issue. Pages 40 to 44 of our appendix, there's this ongoing dialogue, which is triggered by the written motions that don't mention the license suspension, but in a timely way during jury selection, there is this ongoing conversation.
Wasn't the defense under the impression that the judge had ruled in their favor on that issue?
In the sense of People v. Mountain, at the least, the judge had that impression that the attorney took that position, and then the assistant went back to the judge on March 28th on pages 47 to 48 of our appendix and said, we'd like a clarification. Did you say what we thought you said? And then, because the defense attorney won't stipulate.
It was clear, wasn't it, that the defense and the prosecution disagreed on what the judge had said?
I'm sorry, that the defense and the prosecution
disagreed on what the judge's prior ruling meant or should mean?
Yes, but it also is indicative that the judge did rule, and there's language by the judge. I view this as relevant, what he calls intent.
In the vast amount of time
means
you've got
state of
left,
mind.
and all the time you've got left, tell us how you get around Orama.
Sure. There's an irony to the defendant's position. She's claiming that the core responsibility is meaningful notice. The statute doesn't say notice on the record. It says notice. That's the core responsibility. It is the defendant's responsibility to create an appellate record for this Court's review. And while she's claiming deprivation of notice, she's also depriving this Court of any record
understand your
for
point,
appellate
but
review.
on that theory, why wouldn't Kissoon and Tabb and Martin, all those cases, have gone the other way?
Orama and I see my time is up.
Go
May I
ahead,
answer the question?
finish, counsel.
Orama and Kissoon, the attorney there made a record in Orama. In Kissoon, it's there in the record because the judge didn't disclose the full note, i.e. withheld some of the note. In Tabb, I submit, and I'd like to probably come back to this on my rebuttal time because I think it's important in light of its recent issuance. But in Tabb, it's a 511 submission, which by the Court's own rules is not a decision that would speak on such an issue of statewide significance.
You're saying Tabb is wrong?
No. I'm saying that the issues, the way the issue of Orama was presented to the Court, and the way in which this Court didn't speak on the issue and address it fully, that record, I submit, was so confusing that if you apply the presumption of regularity in effect as you were looking at it, that I could see why the Court.
Okay, counsel. We've got you'll come back to it. I think you should on rebuttal. Go ahead, counsel. Why don't you talk about the mode of proceedings, alleged error first, since that's what he was just talking about.
Okay. My name is Frances Gallagher, and I represent Ms. Caban. And under Orama, the Court has the core responsibility when it receives a jury note to apprise counsel of the contents of the jury note, to receive counsel's suggestions, and to apprise counsel of his prospective reply.
And that wasn't done here, you say?
That was not done here. There were 4 jury notes, and there is an absence of a record that this core responsibility.
Were we confused in Tabb, or is Tabb the record confusing there as to what went on? Seems to be their argument that Tabb is not really on point, as counsel said.
I think Tabb is perfectly clear. It says that in the absence of a record that the judge complied with his core responsibilities, a mode of proceedings error has occurred, and reversal is required.
What's the purpose of putting it on the record?
The purpose of putting it on the record is for appellate review, but more important, Orama said that this was a very critical juncture in the trial when counsel's suggestions and input were quite relevant, and we can see that here. And while preservation isn't required, we can see that one of the last questions that the jury asked was about the suspension of the license. And
the people seem to say that the defendant can't establish that the judge didn't share the notes with plaintiff's attorney.
But the
Is that the way we look at this?
That's not the way TAB looks at it. The presumption is quite the opposite. The burden is on the judge to make the record, and it's fully within his power to make the record.
So we can't assume that the judge had an informal bench conference with counsel or in the robing room, et cetera, and then they came out and they made a record?
Not
didn't perpetuate everything that was said. We can't assume that here?
Not pursuant to TAB, and it's perfectly logical because it is such an important point of the trial. It's perfectly logical that in the absence of the record, the presumption should be in favor of the defendant.
What were the mistakes that the judge made in addressing the notes?
Well, his first note was fairly cursory. I mean,
He summarized it. He summarized the note, correct?
But I mean, did he tell the jury something they should not have heard?
In the last note, he informed the jury that recklessness and negligence were not mutually exclusive. And while my adversary cites a lesser-included offense case, of course, one can't be reckless and negligent at the same time. One can't, fail to perceive a risk at the same time as being reckless.
Does it matter how cursory the note is? Is it an what's the rule here? Does it matter what the nature of the inquiry is? Let's say it's just a readback, as some of them were. What's the difference? Is there a difference depending on what the note is, or it's a note he doesn't follow in your from your perspective, TAB, and that's it? Does it follow what I'm asking?
The only two exceptions that this Court has held took place in Starling and in Rosario, de Rosario. And in Starling, the Court read the note and simply reread responses that it had read. And de Rosario were oral questions which the lawyer held contemporaneously. Otherwise, in the absence of a record, that the judge complied with his core obligations, the defendant prevails.
Period. That's the rule.
Yes.
Okay. Anything else, counsel?
Oh, yes.
Go ahead. You have the other issue. You want to go to?
The negligence issue. The First Department was absolutely correct to conclude that the testimony that Ms. Caban's license was suspended at the time of the incident had no relevance to the case.
And in common sense, isn't it more negligent to make the same mistake a second time than the first?
Well, first of all, I have to take issue that the first incident was that relevant. I think the judge made a perfectly correct ruling. We didn't know anything about the pedestrians in the case from the police, from the people's offer of proof. We didn't know the speed. We didn't know the circumstances. And in any event, as you pointed out, the issue in this case was the suspended license not relevant.
That's all that was before the jury was the suspended license. None of the underlying facts of what led to that, right? That's all that went before the jury.
The suspended license, right, plus the people's argument that the suspended license was relevant to negligence, plus the
But they had no evidence of the underlying facts that led to that suspension of the license.
Right, but we know that a suspended license is never negligent, that negligence is the failure to perceive a substantial and unjustifiable risk, that the conduct that resulted in death was in fact likely to cause death. The negligence is always with respect to a result.
Wouldn't a more prudent driver refrain from driving after her license was suspended?
But that's not the question. The question is, did the conduct that resulted in death demonstrate a substantial and unjustifiable risk?
But he's not saying that this by itself does it, that the license suspension would by itself make a case, but doesn't the fact that she disregarded the license suspension contribute to the blameworthiness of her conduct?
It's not did it contribute to the blameworthiness of his conduct. Did it contribute or cause the death?
Well,
did
in a
it
sense,
increase? In a
but-for sense, it obviously did. If she hadn't done it, she never would have hit anybody.
Did it increase the death? But-for really isn't the test. Proximate cause is applicable in civil cases and is certainly applicable in criminal cases. And
so the question then is, should somebody whose license is suspended foresee that it's somewhat more dangerous for her to be on the road than somebody else?
The question isn't just a general blameworthiness. It's not just a general risk that some bad things will happen when you step into the car. The question is, did the conduct that caused the death demonstrate a substantial and unjustifiable risk that death was likely to occur?
Well, then why wouldn't the underlying conduct that she had previously put the baby in the back seat without securing the child and kind of went in reverse fairly quickly and was stopped by the bus, why wouldn't that be relevant to show that she had a state of mind that she well knew she wasn't supposed to back up quickly like that on public highways?
Well, there's not such a congruence between the two incidences I think you're suggesting. There wasn't
she had to hit
mention of
somebody and she
pedestrians.
had to hit a pedestrian in the first instance for it to be relevant?
We had to know something about pedestrians. I think you're suggesting that she was somehow unnoticed of a risk. And we don't know enough about the first incident to inform us as to the second. And secondly, the question is, what did she do here? And did it breach a standard of care? And if you're simply saying she backed up previously in violation of the law once, that becomes a propensity argument and propensity evidence.
Well, it's part propensity, but it would seem to me that if somebody said to a person, you're not allowed to drive because the way you drive is dangerous to other people, and you say, well, you may think that, and you may take my license, but I'm going to drive anyway, that may have a tendency to show that you're being reckless.
The point is it negligent with respect to any bad result? Negligence is defined as a specific result defined in a statute. The result here is death.
Suppose she had been stopped by a police officer 5 minutes before this accident, and the officer said to her, you don't know what you're doing, you're a careless driver, get off the road. And she ignores that warning. Would that be relevant to this incident?
In my view, you look at the evidence that caused the death.
So you would say no to that?
To put that before the jury, I think would be improper.
Well, let me ask you another hypothetical. If I go through a red light this week and I get a ticket, and then 2 weeks later I go through another red light and I hit a car and kill someone, is it solely propensity?
Well, first of all, can I just step back and say that none of this is at issue in the case. The question is whether the license suspension, whether the authority to drive is at issue in the case. And all the cases tell us that the authority to drive is never at issue in a criminal negligence case. And even though
can I ask you to answer my hypothetical?
Even though
is it solely propensity? It has nothing to do with state of mind?
Unless it had something to do with her perception of the risk in this particular case, I think the answer is no.
But it wouldn't. Why shouldn't that first ticket make her more sensitive to the risk, or make it less excusable that she failed to perceive the risk?
Wait a second. You're talking about the...
Judge Graffio's hypothetical. She gets a ticket for running a red light.
Okay.
If she's a sensible person, she might think, maybe I should not run so many red lights.
I'm sorry. Maybe
Doesn't that make it more negligent for her to do it the second time?
Your hypothetical is that she ran... Could you repeat it, please?
Well, it's just someone who's gotten, you get a ticket for running a red light. A couple weeks later, you do the same behavior, but this time you cause an accident and you kill someone. So I'm just asking, is your response strictly that it's merely propensity evidence, or does it show a greater awareness of the risk and an inclination to disregard the risk?
If there's an adequate congruence between the two incidents, yes, I think the first could inform the person as to the second. We didn't have that here.
Why don't we have that here? It's the same vehicular behavior. She's backing up on a busy city street.
We didn't know anything about the pedestrians in the first incident. We don't know anything about the speed in the first incident. We don't know anything much at all.
Isn't it worse? I mean, she knows she's not supposed to do it even if there are no pedestrians there. And she does it when there's a pedestrian crossing. Maybe she didn't see him, but that's sort of the... So it seems to me, isn't that the message they were trying to send when they suspended her license? You can't back up just so you don't see pedestrians. You don't know what might be there.
But the question is, I mean, she did look. She took proper precautions. She didn't see the pedestrian. I mean, these are the acts that one should be looking at when one is determining whether or not the people have proved criminally negligent homicide.
How do we know all that, what you just said?
How do we know?
That she did look, that she was cautious, that...
It's in the record.
But from whom?
She didn't testify, did she?
She didn't testify. There was a statement read. It was a police statement that was read into the record.
There was a police statement that the policeman observed her doing that?
It was an interview, I think, that was introduced.
Interview of whom?
Interview, I believe, of the defendant.
So if it's of the defendant who says, I was safe, I was looking, I did everything right, isn't it even more germane that she pled guilty to, as Judge Graffio described it better, but of essentially the same facts? I mean, of pulling away and with an infant in the back seat and avoiding a policeman and being in a bus zone and all that went with that first suspension? I mean, it seemed to me to go to her credibility, if nothing else.
But credibility, I mean, that's not the issue here. The issue is whether the suspension was relevant.
Just the bare bones suspension?
Yes.
Okay.
Yes. And I'd just like to introduce, to discuss Cabrera. The Cabrera didn't change the calculus at all. In this case, Cabrera was about license restrictions. License restrictions don't inform us. As to license suspensions, the cases are clearly on point that license suspensions are never relevant because they simply relate to the authority to drive. And I'd also like to mention that this appeal should be dismissed because there's a lack of preservation. Thank you.
Okay. Thanks, counsel.
The 511 decision in TAB is limited to its very bad record and speaks not at all about this axiomatic principle.
Isn't there a thought behind it that isn't there a reason to suggest that it should be on the record? What, it goes to the defendant should have an opportunity to participate, right?
Well,
that's why it's TAB says what it does, even if there's a confusing record in your mind.
Chief Judge Lippman, TAB does not at all speak at all as to the presumption of regularity that's axiomatic. And I'm obliged to point out in the first department where you sat, even People v. Terrence Campbell is a case where the presumption of regularity was applied to an ORAMA situation.
Stepping back, so forget about TAB. I mean, if ORAMA error is mode of proceedings error, which the defendant does not have to preserve, What sense does it make to say, oh, but he does have the burden to make a record?
In People v. Foster, as to antimarchy, a similar mode of proceedings error is in regard to a statutory requirement, and even People v. Kitchen, a right to counsel deprivation involving that fundamental error. This Court said, preservation aside, mode of proceedings error as to antimarchy aside, it does not dispense with the defendant's obligation to create an appropriate appellate record for review.
Well, by that, I assume you're saying, you know, we've got, 6 notes here, I guess 4 of them in question, that if we were to look at the notes, I mean, we can't say we're not going to look at them because it wasn't preserved. But if we look at them and fail to detect any flaws, I mean, it's not an automatic reversal simply because, in somebody's view, there was an ORAMA violation.
Well, ORAMA speaks to meaningful notice, and the court, I just have to speak with precision, because the court duty is just as to notice. That's the mode of proceedings error. Right. But the procedure, which does not mandate rigid adherence to the better practice of putting it on the record, that does not involve that by its nature is not mode of proceedings.
So you never have to put it on the record?
No, I'm saying that it's the defendant. If the defendant claims legal error, even unpreserved, even mode of proceedings error, she has the duty to make a record. The record here is silent as to the core duty under ORAMA.
You have the duty to make a record of an error that you're entitled to rely on, even if you fail to notice it. The rule is that this defendant's lawyer could have been asleep, could have never have read ORAMA, never have heard of it, and she's entitled to reversal. How can you say, oh, but if she doesn't make a record, she loses?
Kitchen and Foster, and the fact that the defendant shouldn't benefit because there are, beyond just the presumption of regularity, there are affirmative indications, including the judge's, when fairly read, declaration that he intended to follow his court
Contrary
duties.
to the whole thrust of what ORAMA is about, to say that they have the burden.
No, I would have to say.
I want to jump on that
Sure.
a little bit. A mode of proceedings error means it doesn't have to be preserved, but there still has to be an error. If everything that the judge did in the 4 to 6 notes or whatever was perfect, if there was no error other than the fact that he didn't notify people, you don't have to preserve it, so you can bring it up. But if there was nothing wrong, you don't get an automatic reversal, it would seem to me.
Kinchin and Foster require the defendant, if she's going to make an ORAMA mode of proceedings error claim, she has to make an appropriate record. I see my time is up. May I just finish with the thought? And there's no special carve-out from the Kinchin-Foster rule, which goes back even further than that, regarding the defendant's obligation to make a record for appellate review, and she can't get appellate relief because of that.
Was there nothing wrong here, counsel? Did the judge do nothing wrong?
I submit beyond the presumption of regularity, there are, and unlike the language even in tab, beyond the presumption of regularity, there are affirmative indications in the record that we point to, including what the judge said he intended to do.
But no record required in terms of the note itself. No record required.
The silence in the record is to the detriment of the defendant because she failed to make an appropriate record for appeal.
Assume the record did show affirmatively that the note was not read, but that nevertheless the judge's answers to the note were perfect. That's still reversible error under ORAMA, isn't it?
If there's a record of a mode of proceedings error under ORAMA and Kassoon, like in those cases.
ORAMA does hold, as I understand it, that no matter how perfect the judge's response to the question, it's a reversal unless he reads the note to the lawyers first.
Because of
this. Do you agree with that?
Yes, to the extent if there's affirmative record proof that the judge deprived the defense attorney of meaningful notice.
So your bottom line is it's their burden.
With respect to the record.
You don't have to make a record. It's their burden.
Yes. Otherwise, we'll be toppling trial convictions across the state because of an ORAMA violation.
Thank you both.